As we know, there are a number of ways in which our work can be enhanced in the sense of critique. There are obviously the primary sources, such as case law and statute, are incredibly important, but we know also that secondary sources are key. And this is absolutely true in the realm of equity as well. There are a number of videos, short summary videos, that touch on both case law but also some secondary sources that the team would also like you to look at. And one of these sources is an essay by Professor Holdsworth, Sir William Holdsworth, sometime Venerian Professor of the Laws of England at the University of Oxford. He, of course, is an incredibly famous legal historian, which helps us think about a couple of things. We're already familiar with Maitland as a legal historian, but of course Holdsworth comes after Maitland and has a similar effect on the development of the history of English law and scholarship relating to that area. But we might think of those two characters, Maitland and Holdsworth, as gatekeepers of ideas, particularly the idea that to account oneself learned in the laws, one must have a good solid understanding of the historical position. That's the first point to note. The second point to note perhaps is that they're gatekeepers of their own work, of course. That's to say, essays that they have produced give us some ideas and thought processes to mull on and focus on. And I think a very good essay that Professor Holdsworth wrote that you might want to look at is a piece that was originally published in 1935 in the Law Quarterly Review. So the citation is 1935, 51, Law Quarterly Review at page 142. And the essay is simply entitled Equity. And in essence, what that essay is an exposition by Professor Holdsworth of the Judicature Acts 1873. And in particular, it's an exposition of the idea of common law and equity, in his view, not fusing, despite the so-called effect of that Judicature, or of the Judicature Acts of 1873, I should say. In other words, despite the so-called fusion or merging of the two jurisdictions, that's to say common law and equity, what in fact Holdsworth is arguing in the essay is that we should be extremely cautious, particularly in the years after 1873, so 1873 as we move towards the end of the 19th century, of considering the idea that those two jurisdictions have merged. Indeed, what Holdsworth attempts to do is argue that equity is still equity and common law is still common law. Indeed, Holdsworth goes so far as to say, in disagreement with Maitland, of course, that equity should still be taught separately, whereas of course Maitland held that because of the so-called amalgamation it might be taught differently, that's to say in small chunks. Holdsworth of course says that equity shouldn't be taught in snippets. It's inappropriate for it to be delivered in that way, which of course is wholly inconsistent with the way in which these videos have been compiled. However, we are still of the opinion, of course, that they're a good mode of causing ideas to be transmitted to undergraduates. So do have a look at that essay, see if you agree with Professor Holdsworth's ideas, particularly in relation to how equity in its early 1880s guise may or may not have been received, and think about how the themes that come out of that essay in the LQR are still potentially relevant today when we consider the deployment of equity. For now, goodbye.